Hello, I am Stephanie Joy, the attorney at All Things Social Security and Joy Disability Law. Your video is about to start. I just wanted to remind you that if you click the join button below, you can learn more about the memberships offered at a very affordable price that can give you a little more direct attorney answers to your questions. Have a great day and enjoy the video. Hey, not too long ago, there was a video share about the SSA-821 and when you would be tending to get one required of you. This could be if you're filing for disability, SSD, or if you are already receiving it, but you started to work, in some shape or form, and you have to give them the information they need to see. If you're hitting SGA, TWP, they need to know all about this work, right? So a person asked, and you'll know that in the 821, if you have one, it asks for your pay stubs. The pay stubs are important because it's going to show how many hours you were working. And, it'll show that you were only working part-time. It'll also show your gross hourly rate. And that's how you can argue that you're under SGA. That's how they'll figure out if you're, under, over SGA or TWP, trial work period. So the question is, what if I don't have my pay stubs? Well, from going forward, keep all your pay stubs for sure. I know that when there's direct deposit, most of these places have it where you can download your pay stubs. It's all the pay stub information. So inquire of the employer about that. Now, someone also asked, my employer doesn't seem to have my pay stubs. And remember, the pay stubs are only generally for the year in question currently, because you don't have a W-2 yet. Let's say we're in 2024, that W-2 is not going to be created until early 2025, because you're still in the middle of your 2024 work year. So if the employer is saying they don't have the pay stubs, I think it's false. The Fair Labor Standards Act requires that they keep all the things that would be in a pay stub for a number of years. So, and think about it. Let's say there's an allegation by an employee, hey, you didn't withhold my payroll taxes, my Social Security taxes. You didn't withhold my income tax you're supposed to withhold, because employers with W-2s are required to withhold income tax on behalf of their workers. So if they have this allegation against them, you can be darn sure they're going to step up with the documentation for the prosecutors or whoever is going to come down, probably the Department of Labor, and put the kibosh on them, because I think the sanctions can be pretty hefty. So I think it's probably BS if they say they don't have that information and it's in the current year. I would think it's still BS if it's in the last few years even. So if an employer tells you that, not to start a rift here, but I think it's probably false. And it's really important that you get these pay stubs, because for most things, when you're filing a claim for insurance benefits, including Social Security disability, the burden is on you. I mean, they see you're working. Now, that's not to say the SSA shouldn't step up and help, because they do have access to some things, right? So if for instance, there's something called a certified earnings record. I think that's the one. You can actually order it from the SSA. I think they charge you though, which is, I think, wrong. And who knows, maybe they don't charge if you have a pending claim. It's something to look into. But I believe it's a certified earnings record. That's where you can get the address and everything of and I think it goes all of your employers in the past, and it goes quarter by quarter. And I think it shows what was reported as your income for that quarter. So at least you can define what you made each 3 months, even if you don't have each pay stub. So it just gets you a little more narrow, because what you're trying to prove is that in none of those months, you want to know what you made each month, what you grossed, because that's going to say whether you are over SGA. If you're over SGA, you're also over trial work period month. And that is something that's going to be important down the road. If you're currently claiming, you might not be thinking about that right now, but it is kind of a shame if you prevail on your claim, you've already used up your trial work period during your claim. Not that that's the end of the world, but remember, the trial work period was a protective period, and now you're outside of that, and they can look at the work you're doing to see if they consider that to show that you could actually do a full-time job. You're not as physically unwell as maybe what you were when you prevailed. So it's good to know whether you're going over TWP or SGA. And when you get your direct deposit or your checks, they're going to be netted out of things, and that's not going to be the right number. It'll be a lowball number, and you will have been making more, and you could be over SGA and not realizing it. So you really have to keep serious track of it. If you know your hourly wage, and this is just for your own edification, it's not going to suffice as the paperwork for the SSA, although they do give you the opportunity to write it down if you don't have your pay stubs. There's some columns there that you can use. So then if you know that you worked absolutely 20 hours a week at $10 an hour, you know what you made for, by and large, for each month, say $800, $840, or $850, whatever. And you know that's under SGA, and it's also under TWP now. So you can write it out. So I would do that if I don't have pay stubs, but I would try to get those pay stubs. They are protective for you. If you know you're under SGA, that's your ironclad proof. Okay. And if your employer is saying they don't have that information, I believe that to be false. If they use a payroll company, they certainly have it. I mean, it's almost ludicrous that they would suggest that. If it's a mom and pop type of employer, I mean, if they're withholding and it's a W-2 situation, I would be shocked that they don't have documentation, because there's a lot that can go wrong for them if they don't. If you are a contractor, of course, you're not going to have a W-2. That would be a 1099, and that's not going to be the hours provided and all that stuff. But that wouldn't be an 821, SSA-821 form either. That would be the SSA-820 for a self-employed person. That would include giggers and other self-employed people. People that get 1099s and people that don't get 1099s. They just get paid by their customer. Yeah, you got to keep track of that too. All right, guys. Just a little word on those pay stubs and what your employer certainly can get his hands on. So perhaps don't let him roll so easily if he says, don't have. All right, bye. Hey, so if the subject matter of the video you just listened to is of interest and you want more on it, stay tuned. Here's another one about the same topic, but a little bit different. Bye now. Hey, good evening. Just going to wrap up the day here, and I wanted to share something with you with regard to the SSA-821. There are often different reasons why the SSA sends these out to claimants or beneficiaries, trying to find certain details. Now, the SSA-821 is the work activity report for employees. So, and that would be versus the SSA-820, which is for work activity for self-employed people. So we're talking about the SSA-821. And what can trigger the request for this can be varied. But here's what happened this week. And we were scrambling a little bit to get the right information in quickly. So this is someone I did not represent, but was going to and am. So I was about to. And when the person had contacted me, they'd already filed on their own. And the SSA had popped out a demand for this 821, and the person was a little overwhelmed. Now, in this case, and this happens not infrequently, when you file your application, they ask you, when did you stop working? And generally, people give the last day they worked. Presumably, they have stopped. Now, of course, it's actually true that a lot of times people have not fully stopped work and they still can file. So I'm not going to talk about that right here. So the person had stopped working, say, the end of 2020. And the other part of the application, I think it's early on in the application, asks about, well, we know you stopped on so-and-so date that you said, but did you have any changes to work before then? Well, it's kind of a loaded question. And I think they're trying to, I will say this, I think this is the SSA's very fine attempt to step up and help determine if claimants have picked the right onset date. So a person who picks, say, end of 2020 as their, well, that's when I stopped working, that was my last day of work, would think that is definitely their alleged onset date, because you can't do it before that. However, at times you can do it before that, because if the work you were doing was not substantial or gainful, that would mean you could go back to when the day after it stopped being substantial and gainful. So in this case, the person had said in their application, of which I was not a part, I came in shortly thereafter. I prefer it the other way. I like to be in before it goes in, but so the person, she put, yes, things had changed as of January of 2023. So that's all they ask about. They don't ask for what the changes were or anything like that. It is just like a yes and no question. So I get when why people would answer it that way. I mean, it's the proper answer that she gave. However, the 821 request is triggered now, and they're not going to let her file leave the field office and go to the state medical workup department at the state level, which is outsourced to the feds for the purpose of SSD and SSI claims. They're not going to let it go there until they get this concrete. So they need the 821 back so they know whether they're setting up the right alleged onset date, because the medical workup people, they have to consider the information from after the alleged onset date. And if you know, it's not that they can't, I suspect they could, don't hold me to this, sua sponte, pick an earlier one, but I'm not positive, because they don't know necessarily all the numbers and all the things that go into insured status and all that. But I suppose it's feasible. But the field office is not sending it up until they have felt confirmed that the right alleged onset date is in there. And like I said, they are giving a chance for an earlier onset date, which is super sweet, I think, doing it on the behalf of the worker. So in this case, the change in work had to do with part of the hours now being remote. And it was because of feeling poor, having more difficulty working in the office, needing a few different accommodations, that kind of thing. So the questions on the SSA-821 are asking about, give us all the pay stubs. We want to see if you were SGA. Well, this is a few years back and there are no pay stubs readily available. However, there are W-2s. And that's because this is an 821. It's a W-2 situation, not a self-employed situation where you have earnings, but then you have deductions for business expenses, and it's a little less clear. So what I wanted to do, because I wanted this to move fast, was just tell the SSA the whole entire year, despite working remotely because of her disabilities, she was earning SGA, and quite above SGA. I mean, it was pretty nice income. So there is no way on God's green earth that number is going to fall below SGA based on that. It's not like she had impairment related work expenses or anything else that would bring it down. So I just wanted to scream it to him, because this is a lengthy form, and we also wanted it to move quickly. So I thought if I could just speak to them. However, I had just gotten involved in the case. And my biggest goal was to get my representation recognized so I can get into the Electronic Records Express, ERE, under this soon-to-be new client, and see all the goods, see what her application said, because she doesn't have a copy, see anything else that might be in there. I want to be in there as soon as it gets to the state level, most particularly because as those medical records start flowing in there, I want to be able to see that. So I ended up, because the 821 would take a little bit of time, not huge time, mind you, but some time. I sent in my representation documents without that, even though it was deadline and it's due in a couple days. But I thought, let them get me on board with the representation documents. Let them do one thing at a time, because sometimes if you give them too much, they can get a little confused. So that's what I did. And then the next day, which was today, we finalized the 821. And, you know, it asked for all those pay stubs, which she doesn't have. So we used the W-2 and made clear all months were above SGA. There were no IRWs to subtract to bring them below. The alleged onset date of 12/2020 is appropriate. It won't be going back to 1/2020 when the person started working some of the hours remotely. Even though, yes, it was a change in work, it's not really a change in the duties of getting, you know, whatever you have to get accomplished. Certainly didn't reduce the pay. So the pay alone was going to be your, you know, Achilles heel on that one. But we knew that, you know, when she filed the right date, you know, and it's funny because a lot of times pro se's file the wrong date. In this case, she was correct. And her date was right. So we did put it together and we got that in tonight, this afternoon. And it is my hope. I did it under separate cover, instead of just trying to squeeze it in with my rep documents and a cover letter, which was, again, I was going to do it all together and say, hey, by the way, she has no, you know, she's all SGA. She has no, her onset date cannot be before 12/2020. But I thought they don't often read those cover letters thoroughly. I even have on my intake, my initial sendings to the SSA checkbox lists right on there. So it's real easy for them. They can't miss it, an X in front of a, you know, a listing. But if I do narrative, I don't think they necessarily read it or take it to heart. So they might just look at the attachments. So an explanation of why this 821 is for naught, was not going to be necessarily going to work, and we wanted some speed here. So we did it separately, got the representation documents in, did the entire 821 simply because when they see it, as opposed to a letter that explains it, like I said, a letter that explains stuff, I feel like it's pushed to the side. The 821, they already demanded. So they're going to be looking at it the second it comes in the door, because that's what they demanded, that exact form. And so we have a little remark in there that there is no change of the alleged onset date, unfortunately, because it would be nice, because all of the work has been SGA and there was nothing to reduce it below SGA. And it's solidly over SGA. It's not like, you know, breathing on the fine line where there might be something that you could subtract. So that is when an 821 is requested, and it's not going to do anything for you, but you have to get it in anyway, because the file will not move on to the adjudicator where it needs to go. Okay, so one more instance of 821 as I come upon them, because there are several different reasons when they go out and different outcomes, I will let you know. All right, have a great night, guys. Bye.